On the afternoon of July 24, 2025, the Seoul Central District Court's Civil Division 41 held the third hearing in the lawsuit filed by ADOR against NewJeans members, who are seeking confirmation of the validity of their exclusive contract. Now, during the hearing, ADOR claimed that Min Hee-jin was behind NewJeans' attempt to terminate their exclusive contract from start to finish. In contrast, NewJeans' legal team argued that the group had lost trust in ADOR, and they illustrated their position through a series of very interesting analogies. The members also submitted a petition to the court, stating that being told to return to ADOR is basically like asking a school bullying victim to go back to their abuser. The petition was made public during the proceedings, according to the Korean media. Meanwhile, NewJeans lawyers raised objections to the courtroom disclosure of private text messages between former ADOR CEO Min Hee-jin and her deputy, Lee Sang-woo of ADOR at the time, former deputy. But both ADOR and the presiding judge expressed difficulty in understanding the basis for such objections, as they noted that the material had already been made public through previous reports. Ultimately, the disagreement between ADOR and NewJeans remained unresolved, but the court agreed to schedule a mediation session, leaving open the possibility of a negotiated settlement. Now, so that's basically a summary of what happened. But in this video, I'm gonna break down the latest courtroom developments, including newly revealed KakaoTalk messages or old ones, and orchestrated PR strategies by Min Hee-jin, and ADOR's claim that Min Hee-jin planned the group's exit from the start. And we will examine both sides of the case. While we ask, why is NewJeans arguing that returning to ADOR is like sending a bullying victim back to their abuser? And why did their lawyer try to block evidence already reported in major outlets? Okay. Make sure you bring a cup of coffee and make yourself comfortable, because there are a lot of juicy materials we're going to talk about. And I have also provided some past materials as context, as I always do. Okay. Now, to provide you with some background information, previously in November of last year, NewJeans held an emergency press conference announcing their intention to terminate their exclusive contract with ADOR, right? In response, ADOR filed a lawsuit the following month seeking legal confirmation that the contract remained valid. ADOR also filed for an injunction to preserve its status as the group's management agency, and to block the members from signing independent endorsement deals. The court sided with ADOR, effectively preventing NewJeans from engaging in solo activities and forcing them to suspend promotions. Also, the court granted ADOR's request for indirect compulsory enforcement. The ruling stated that NewJeans is prohibited from engaging in independent or third-party entertainment activities without ADOR's prior approval until the first trial verdict is delivered. And any violation would result in a 1 billion Korean won fine per instance per member, payable to ADOR, which I have talked about on my channel with this video and this one. Okay. Now, during the hearing that happened on July 24th, both sides delivered PowerPoint presentations to argue their positions, starting with ADOR, the plaintiff. Okay, ADOR basically emphasized two key points as the core of the case. The company's massive investment in NewJeans members as trainees, and a sudden change of heart of the members after achieving success as entertainers. So ADOR stated, or their lawyer stated, HYBE invested 21 billion Korean won in the defendants, NewJeans members. Based on that investment, ADOR provided extensive support across the board. ADOR staff worked solely for the group's success, spending 7 billion Korean won on their debut album alone. The music video cost 2 billion Korean won, and a dedicated fan platform was built just for them. These were unprecedented privileges for rookies. HYBE and other labels also gave their full backing. Thanks to this overwhelming support, NewJeans achieved explosive success from the moment they debuted. So yes, I'm not sure if you remember or care. When NewJeans debuted, they dropped multiple music videos. Basically, for each track on their debut album, starting with Attention, official MV, performance version, and HYBE BOY, with P, not B. They made a video for almost each member. So there's an intro, there's a Minji version, Daniel and Harin version, Hein version, Honey version. They also had made an official music video for Hurt and Cookie. And for HYBE BOY, they dropped 2 additional videos, Performance Version 1 and Performance Version 2. And speaking of the fan platform, it is true. HYBE created a separate fan platform called Phoning for NewJeans and their fans. Even BTS uses Weverse platform. So this is a phenomenal privilege that HYBE gave to NewJeans. Probably this is an idea made by the woman, probably Min Hee-jin, but yeah, indeed, NewJeans members enjoyed such privileges from the very beginning. ADOR lawyers continued. The Seoul High Court has already acknowledged that the foundation of NewJeans' success lies in the full support they received from HYBE and ADOR. Even the defendants, NewJeans members and Min Hee-jin, can't deny that. Yet, only 2 years after their debut, the defendants attempted to walk away from ADOR. This kind of one-sided termination is a clear breach of contract. The High Court also noted that ADOR would suffer serious damage and ruled that such a unilateral termination cannot be allowed. And indeed, that's the case. Also, ADOR presented portions of KakaoTalk conversations involving former CEO Min Hee-jin. In one message from March 2021, I think this is the one that they're talking about, Min Hee-jin reportedly told a shaman, "I'll take them like a company merger in exactly 3 years. I want them." I think that line was delivered by the shaman, actually. 딱 3년 만에 기업 합병되듯 가져오는 거야. In just 3 years, you'll bring it in like a corporate merger. Yeah, I have translated this in English before. And ADOR claimed that she followed through with that plan in 2024. Another conversation from March 14th, 2024 between Min Hee-jin and former ADOR Vice President Mr. Lee Sang-woo was also revealed. Now, I think this one is not revealed through the media because I have saved all the KakaoTalk conversations that were already revealed through Korean media and saved them as files with dates. But March 14th, I don't have that one. But I think this is so interestingly, there's a message that happened on March 6th, 2024, where Min Hee-jin calls one of the NewJeans members as fatty, and then she drops some curse words, which is and then on March 15th she discusses with Mr. Lee Sang-woo, the vice president, former vice president of ADOR, discussing with potential investments that could be made by a third-party company who could help her take away NewJeans from ADOR. Okay. And then, this is another KakaoTalk message conversation that happened on March 15th. Also discussing with about potential investments and how much do they have to pay to take away NewJeans members. At least 600 billion Korean won. Even that was cheap from Min Hee-jin's perspective. Okay, so where was it? Yeah, in the chat, Min Hee-jin said the general consensus is to take them out. Let's take a closer look at the contract. To which Mr. Lee Sang-woo replied, "You will be the one to leave and start the company." Okay, all right. So I guess that's what the lawyers, ADOR's lawyers, said during the court hearing on July 24th. So that was probably a newly revealed KakaoTalk message that we don't have access to. We only hear about this because the Korean media journalist attended the hearing in person and told us about that through these articles. All right. So yeah, here are some related evidence. Attempted takeover planning, and also this one. According to May 2024 조선일보 report, Min Hee-jin appointed Mr. Lee Sang-woo, who was back then HYBE's head of investor relations, as ADOR's vice president. Okay, she promised him 0.35% of the proceeds ADOR would gain after separating from HYBE. In January, Mr. Lee met with Capital N to discuss an IPO for ADOR. And from February onward, he held multiple meetings with the BTS dedicated accountant, analyst, and law firm executives. One financial institution was reportedly even introduced as a prospective lead investor, Jeonju. Min Hee-jin also personally attended meetings with VC investors and reportedly said the general consensus is that we should take NewJeans with us. She instructed her team to rank potential investors by investment size from 1 to 10. So these details suggest that long before the public dispute, there was already a systematic plan to break away from HYBE and launch ADOR independently and take NewJeans along, not by negotiation but by internal maneuvering. Okay, so even though there aren't like these KakaoTalk message like screenshots or something, we have already knew about this based on the reports that were made last year. Again, this was from May 17th of 2024, released by 조선일보, one of the major Korean media agencies. All right, at that point, here's something interesting. The defense team representing the NewJeans members objected to the disclosure of the KakaoTalk messages, arguing that the evidence had been collected through unlawful means and should not be made public through media coverage. Okay, there we go again. ADOR, however, countered by saying, this isn't anything new. The material has already been made public. And indeed, we have seen this and heard about these before. The presiding judge also dismissed the objection, remarking, even I know about this. Do you really think the reporters here don't? 저도 아는데 기자분들이 모르시겠나. So that judge is speaking to the NewJeans lawyers, right? Even I have already heard about this and seen these messages. Do you really think these reporters attending this hearing in person don't know about these? This has already appeared in the media multiple times. And the judge added, you need to also respect the other party's right to argue their case. And this is here's another report released on July 24th talking about that incident. Okay, the legal team representing the NewJeans members reacted strongly to ADOR's claim that former ADOR CEO Min Hee-jin had attempted to take the group with her. Let's see. Before the presentations began, NewJeans attorneys formally requested that while submitting allegedly unlawfully collected evidence to the court was acceptable, it should not be mentioned during the public portion of the trial. The court accepted the request, but during ADOR's presentation, the team brought up a KakaoTalk message that Min had sent to an acquaintance, saying, I'll take them in 3 years. This drew an immediate protest from the NewJeans side, who argued, we repeatedly asked for that evidence not to be shown in public court, yet they are deliberately airing it. The judge dismissed the objection, saying, even I know about this. Do you really think the reporters don't? When the defense continued to push back, the judge firmly responded, you can't interrupt opposing counsel's presentation like this. Please refrain. We have all heard the accusations about taking the group already. Here's another report. During the third hearing between NewJeans and ADOR, the legal team representing the NewJeans members expressed discomfort when ADOR attempted to present private messages exchanged between Min Hee-jin and the former ADOR executive, but neither ADOR nor the court appeared to agree with their objection. Okay. The judge appeared skeptical of the objection, replying, "Even I know about this. Do you really think the reporters don't?" So yeah, that was pretty interesting how the judge reacted to the NewJeans lawyer's objection. All right. Now, ADOR refuted that claim, saying they haven't even explicitly said it was illegal. The Yongsan police confirmed the evidence was lawfully obtained, and the claim of a violation of the Information and Communications Network Act was already dismissed. These weren't private conversations involving the members themselves, only between Min Hee-jin and her staff. If their reason for terminating the exclusive contract is the alleged group poaching, why are they trying to block detailed evidence that rebuts that claim? The judge ultimately sided with ADOR on procedural grounds, saying, "Please respect the opposing side's right to argue. It's not appropriate to interrupt a 30-minute presentation. Everyone has a chance to give a final statement, so don't block their opportunity to speak," effectively warning the NewJeans legal team to back off. Now, here's another detail. In the end, ADOR chose not to present all of the prepared KakaoTalk messages during the public session, but in their closing argument, they pointedly stated, "Despite hours of rebuttal, the other side still hasn't properly addressed the contents of these conversations. We ask the court to review them carefully." Okay, so the judge would look at them separately. Now, let's go back to the proceeding. ADOR continued its presentation, stating, on March 14th, 2024, Min Hee-jin gave explicit orders to draw up a concrete plan. That plan clearly stated the ultimate goal, to break away from HYBE. 궁극적으로는 HYBE를 빠져나간다. It also included strategies such as raising plagiarism allegations against Islet and others, and deliberations on how to strategically leak this information to the press. Then, on March 29th, she involved the defendant's parents, NewJeans members' parents, gave instructions for execution, and proceeded step by step. And here's some background articles referenced that I will reference from the past, from last year. Okay, so here's an article titled, "They want to make themselves," we want to make ourselves untouchable and ultimately break away. Okay, so this one is reported by 세계일보 on April 23rd, 2004. Internal documents have surfaced that appear to show deliberate plans by ADOR leadership at the time, so that is Min Hee-jin, to gain independence from HYBE. One document was labeled under the section number 5, objective, and reads, "Make ourselves untouchable inside HYBE and ultimately break away. 우리 못 건드리게 하고 궁극적으로 빠져나간다." The phrase "make ourselves untouchable" is interpreted as an intention to collect internal information that could pressure HYBE. Despite ADOR owning only 20% of the label shares, or Min Hee-jin owning only 20% of the label shares. The ultimate breakaway refers to securing full management independence. Okay, and here's another article. So that was that. Yeah, here are some KakaoTalk messages that I've got from last year. This one is from March 18, 2024, where the VP Lee Sang-woo discusses with a representative or an executive of a investment firm, and then he brought the updates back to Min Hee-jin to discuss their plans. And then in February and March of last year, Min Hee-jin made plans even more concrete. Okay. All right. And then do I have? Yeah. Anyways, so that was from last year. And then I think this was also from last year, reported by Seoul newspaper on April 23rd. According to Seoul Shinmun, during an internal conversation at HYBE, Min Hee-jin reportedly said, "Islet copied NewJeans. TUS, TWS copied NewJeans, and even Rise of SM Entertainment copied NewJeans. A March 29th document reportedly includes the goal: ultimately break away from HYBE, make ourselves untouchable within HYBE. In another HYBE audit document, Min Hee-jin was quoted saying in a private conversation, "Honestly, Bang Si-hyuk just copied my stuff and got to where he is. 사실 내 거 뺏기다 여기까지 온 것." HYBE launched the audit over concerns that Min Hee-jin and close associates were leaking confidential contracts to external investors and discussing ways to offload HYBE shares in ADOR. HYBE suspects that the executive also shared trade secrets and internal documents necessary for ADOR's separation. HYBE has indicated that, depending on the audit outcome, it may pursue legal action based on the digital evidence collected. So that was from last year. All right, let's come back to the proceeding. ADOR stated the following in court. On March 30th, Min Hee-jin instructed that a letter of complaint be drafted under the names of NewJeans' parents. Following her orders, Mr. Lee Sang-woo created a file titled Mother's Complaint Letter. Min Hee-jin specifically told him to cite provisions of the exclusive contract and to make that point firm. She also said it should not be sent under a lawyer's name, but rather in the name of the parents. She directed Mr. Lee to include allegations of plagiarism and other issues. Mr. Lee then revised the document under the parents' names and added the points Min Hee-jin had requested, faithfully executing all of Min Hee-jin's instructions. Min even gave edits down to specific wording and co-authored the letter with Mr. Lee. She ordered the letter to be sent not to HYBE but to ADOR, saying ADOR would need it as evidence to terminate the exclusive contracts. And of course, that was ADOR where Min Hee-jin was still the head. Okay? The parents ultimately submitted the letter to ADOR per Min Hee-jin's instruction. When Mr. Lee expressed concern that the whole thing might look staged, Min Hee-jin told him not to worry since there was no hard evidence and to act confident. So here is a conversation that happened on March 30th, 2024. Min Hee-jin talking with the VP of ADOR. And then here's a KakaoTalk message that happened on March 30th and April 20th. I have translated before. Conversation between Min Hee-jin and former vice president of ADOR. The day before NewJeans' parents sent a complaint to ADOR. Did you write this from the parents' perspective? Yes, said VP Lee Sang-woo. We should think more about the tone of delivery. We can take advantage of the fact that the parents didn't sign a contract with HYBE. Is there anything in the exclusive contract that mentions HYBE? There's nothing related to HYBE. The contract is between ADOR and the artist, VP said. Haha, hoo, Min Hee-jin said. Is there any other clause they could raise an objection to? Now, on April 20th, 2 days before HYBE launched an audit into ADOR, the parents should be the ones to report this to the FTC. It would look odd if we filed the report ourselves. Yes, that seems much better, VP said. It's easier for the parents to file the complaint. If they do it, it better exposes any gaps. Whereas if we, as a subsidiary, file the complaint, it could lead to arguments about regulations and legalities. Yes, exactly, the VP said. And then, this is about the KakaoTalk message that basically says that, even Min Hee-jin was aware that copycat allegations would not work, but she doesn't care. All that matters is headlines, right? They don't care about, quote unquote, fixing the HYBE. It's all about the members' mothers raising objections and complaints, and then the world will flip upside down. Okay. ADOR also presented a PowerPoint showing the document's revision history, which confirmed Mr. Lee had modified the file in line with Min Hee-jin's instructions. They further revealed Min Hee-jin also ordered a separate complaint letter to be sent to HYBE. She shared this document with legal counsel. She even told staff to revise the draft to sound like it came from Kane's father, one of the NewJeans members, the maknae, the youngest member's father. Okay? And here's a related report. released by Dispatch on June 13th, sent the email in Hane's dad tone. HYBE versus Min Hee-jin, 26 billion Korean won legal showdown. HYBE and Min Hee-jin are locked in a heated legal dispute over the legitimacy of her contract termination. HYBE claimed Min Hee-jin received 2.7 billion Korean won in compensation in 2024, and despite that, she was plotting to take NewJeans behind HYBE's back. HYBE added, she had a deliberate plan to remove NewJeans. That very attempt is grounds for termination. The termination notice was therefore lawful, and any put option claims following that are invalid. They cited specific breaches of contract. Starting in March 2024, Min Hee-jin began influencing the members' parents. She instructed an ADOR staff member to impersonate a parent and send complaint emails to HYBE. She told them exactly what to write. Use Kane's father's tone in the email. Send it using Danielle's mother's name, and so on. These actions amount to clear betrayal and violate the shareholder agreement. Okay, so this was this special article from June 13th of this year, 2025. Now back to July 24 proceeding. ADOR argued this complaint letter, drafted exactly as instructed, was ultimately sent to HYBE. They even shared it with the legal counsel, describing it as the #1 justification for terminating the exclusive contract. Yet, despite this, they intentionally blocked any meaningful dialogue between ADOR and HYBE. That's because what they really wanted was not resolution. It was contract termination. They kept sending these letters to HYBE and ADOR in order to manufacture a pretext. ADOR went on to state, they also launched a coordinated media campaign. Mr. Lee created 7 agenda items for a public narrative campaign and reported them to Min Hee-jin. On April 16th, Min Hee-jin gave the order to begin the campaign. From April 22nd until the contract termination on November 28th, they carried out this media operation in stages. Those same 7 points are now being cited as reasons for the contract termination. It's clear that Min Hee-jin was behind it all. The defendants' mothers were also instructed to join the media push, and they did. On September 11th, the defendants themselves went live and criticized both ADOR and HYBE, and again, Min Hee-jin was behind that. On October 16th, the defendants appeared at the National Assembly to publicly criticize ADOR and HYBE, and again, it was orchestrated by Min Hee-jin. From start to finish, Min Hee-jin was the one behind the contract termination. Okay, and here's a KakaoTalk message from February and March of last year. Min Hee-jin allegedly said, February 4, 2024, 1 year before BTS returns from military service. This is when HYBE is at its weakest. We end HYBE and Pang Seok at this time. But then, on March 29th, she said, we're speeding up the plan. On April 30th, we sent the first email and launched the attack. Since we will go to the second round anyway, there's no reason to delay. Start the attack. Meanwhile, we prepare for the media war. No interest in fixing issues by April 20th. The goal is to raise external issues. The best outcome will be if HYBE, in order to avoid a major crisis, comes to me with a compromise. Now, finally, ADOR framed the case in broader industry terms. The heart of this matter is about offloading the risk of failure onto the agency while trying to keep all the benefits of success for themselves. That approach undermines the very foundation of the K-pop industry. Okay. Now, interestingly, here's some related industry response. 5 major music associations united against tampering, K-pop tampering, saying that NewJeans' case threatens to undermine industry stability. So, in response to the growing concern over high-profile artist agency disputes, 5 major Korean music organizations the Korean Management Union, Korea Entertainment Producer Association, Korean Music Label Industry Association, Korea Record Industry Association, and Korean Music Content Association have called for systematic and public awareness reforms to stop tampering practices in K-pop. Okay. Now, back to the proceedings. ADOR also cited the previous court decision and proceeded to rebut each of the contract termination claims raised by NewJeans, including the music industry report, Hani's ignore her allegations, comments made by a HYBE PR team member, plagiarism accusations involving Islet, the dispute with Dolphin Kidnappers, and the issue of producer lineup preparations. And this is something that was discussed in this article by Dispatch that was released on March 8th. So here's a summary of ADOR's main rebuttals and legal points. Okay, first, ignore incident. ADOR refuted NewJeans' claim that a Belief Lab manager or protocol staff told island members to ignore Hani. They pointed out, Hani told Min Hee-jin that the members did greet her, and the term ignore, 무시해, was first brought up by Min Hee-jin, not Hani. And the incident was minor, and Hani herself didn't see it as serious. About the music industry report, 뉴아르. ADOR clarified that 아르 in 뉴아르 stood for IVE, not Islet. Islet hadn't even debuted at the time of the report. The document reflected a personal opinion, not HYBE's corporate decision. The report was reviewed multiple times by Min Hee-jin later, suggesting deliberate misinterpretation. What about this? Album undermining. ADOR responded to claims of undermining by HYBE's PR head, saying the correction was factual, not only in Japan but globally. Misrepresenting numbers without correction could violate securities law. The gaslighting comment was taken out of context and was not intended as personal insult. The staff involved was removed from PR duties. So, yeah, this was, you know what, go check out the related video on my channel if you're interested in this case. The video is already getting too long. What about Islet copying accusation? ADOR denied that Islet was a copy of NewJeans. You know, proposal templates may look similar across HYBE teams. The actual concepts differ. Similar aesthetics during holidays or promotions aren't proof of imitation, and Min Hee-jin herself once admitted that plagiarism is ambiguous. 표절은 애매. Okay? And about the leaked trainee videos, ADOR stated they contacted Dispatch over 3 times to take down the videos. Over 200 instances of leaked footage were removed or blurred, and they took appropriate actions to protect NewJeans' rights. About Dolphin Kidnappers, ADOR emphasized the production group violated contract terms by posting music videos without prior written approval. Even Apple, the sponsor, complained. And legal action was to protect artists' rights, not sabotage partnerships. Okay. And about the advertising disputes, after publicly stating they would honor schedule ads, NewJeans members refused to sign off on final materials. They even contacted luxury brands directly, asking to exclude ADOR from future campaigns. In fact, this is the first thing that they did after they unilaterally terminated the contract, right? At the time, NewJeans did not offer rebuttals on this point during the hearing. So everything that I'm discussing right now, you know, with these was what, you know, NewJeans' lawyer said back in March, okay? And it seems like that's what they emphasized again during the hearing on July 24th. That was this. About tampering allegations, ADOR said Min Hee-jin had planned the contract exit from as early as March 2024. She orchestrated parents' complaint emails and the members' live streams. Even Hani's National Assembly appearance was allegedly pushed by Min Hee-jin, and all actions point to tampering for personal benefit while exposing NewJeans to legal risk. And again, no direct rebuttal from NewJeans was made on this point. How about this? Activity planning and production. ADOR explained, as early as October 2024, they were planning 2025 activities, including fan meetings, tours, and albums, and they had lined up global producers to support NewJeans' direction. And progress was halted, however, due to the members' refusal to cooperate. What is this? If Min Hee-jin returns, production plans can resume. Oh yeah, Because remember, HYBE and ADOR, at least on the surface, welcomed Min Hee-jin to come back to ADOR as a producer for NewJeans. It's just that she cannot be the CEO. But still, she refused. Okay? And what about this? In the closing statement, ADOR CEO Kim Joo-young said, "We filed this injunction for one reason only. We want to continue working with NewJeans. Everyone at ADOR is waiting. Please give us the opportunity to support them with everything we have." All right. So what does this mean? ADOR's legal strategy focused on dismantling each of NewJeans' listed reasons for terminating their exclusive contract. Like from factual clarifications to legal defenses and accusations of misrepresentation. ADOR aimed to show a pattern of this deliberate narrative construction led by Min Hee-jin and contractual violations by the members of their or their parents, and a refusal to engage in genuine resolution. They also argued that the alleged harm was either exaggerated, taken out of context, or manufactured for the purpose of breaking the contract, not a result of agency failure. All right? And that's what they emphasized again on July 24th during the third hearing. ADOR argued, "It is the defendant's responsibility to prove grounds for terminating the exclusive contract, yet they have failed to do so. In fact, what is being confirmed through this process is the absence of valid reasons for termination." They continued, "If the contract remains in effect, the defendant can resume top-tier entertainment activities and be freed from penalties or damages. More importantly, ADOR is still preparing for the defendant's comeback. And our staff members are sincerely awaiting their return. This is why the High Court also ruled that returning to ADOR would be in the defendant's best interest." They added, "If the contract is broken, it would cause serious harm not only to the defendants and ADOR, but to the K-pop industry as a whole. ADOR would lose its only artist and source of revenue. It will discourage all future investments, making it impossible to train the next generation of talent, inevitably leading to collapse. For the sake of the defendants, for ADOR, and for the future of K-pop, maintaining this contract is necessary. We respectfully ask for a ruling that allows everyone to win." Okay, so that was what ADOR's lawyers said during the hearing. Now, before we move on to NewJeans' side's arguments and their presentations, I'm going to stop right here, and then I'm going to pause, take some break, and have some lunch. And I'll make a part 2 video because, this is going to get long. And then ADOR's lawyers, not ADOR's lawyers, NewJeans' lawyers were very talkative, I would say, according to the Korean media. That's the impression that I got from the report. And there were some juicy and interesting analogies that they made. So we will talk about that in part 2 video. All right. But overall, there was nothing groundbreaking that came out of ADOR's lawyers' presentations because everything has been, revealed. It's just that there's too much materials that have been revealed and too much stuff to talk about. So for a lot of people, I'm, pretty sure it's kind of hard to track everything. So I think this proceeding and this hearing was a good reminder of what exactly has happened, both in terms of, Min Hee-jin's secret plans behind the back and how everything has been happening according to her plans and how NewJeans members and even their parents, cooperated. Okay? And even I sometimes have difficulty, tracking everything, including these KakaoTalk messages. And it's all there. Like Min Hee-jin's secret plans and what she really wanted. Everything is already there. So yeah, it was a good opportunity for me to go back. All right, so let's stop here. Let me know what you think about ADOR's lawyers' arguments. Did they make themselves clearly? And pretty soon I'll make part 2 video. All right, see you soon. Bye bye.